Good evening, Nigerian people. Good day to everyone out there listening to me. I hope everyone is staying strong and staying jugging. Our today's matter arising says Nnamdi Kanu vows to challenge court's ruling affirming IPOB's proscription. Nnamdi Kanu has spoken up for his people and for the society under his ruling that he's going to challenge the courts. So let's get to the contents of the date, not exactly this content entails. Nnamdi Kanu, leader of the outlawed indigenous people of Biafra (IPOB), has vowed to challenge the Court of Appeal judgment, affirming the proscription of IPOB as a terrorist organization. Aloy Ejimakor, in a statement on Friday night, said Mr. Kanu stated this when he and other members of his legal team visited the IPOB leader on Friday at the facility of the State Security Service. Premium Times earlier reported that the Court of Appeal in Abuja on Thursday affirmed the proscription of IPOB in Nigeria. IPOB is a group leading the agitation for an independent state of Biafra, which it once carved out from the southeast and some parts of the south-south Nigeria. The Nigerian government, under the administration of President Muhammadu Buhari in 2017, proscribed the separatist group. A federal high court in Abuja formalized the IPOB's proscription and tagged the group a terrorist organization. Speaking through Mr. Ejimako, his special counsel, Mr. Kanu argued that the judgment affirming IPOB's proscription was faulty. The ruling yesterday, Thursday, by the Court of Appeal, affirming the proscription of IPOB as a terror group, will live in infamy and thus shall be resisted rigorously within the parameters of the law, municipal and international. Sooner than later, it shall be demonstrated that the judgment did not pass the muster of the Nigerian Constitution and the status pertinent to it, he said. Mr. Ejimakor said a major issue which the legal team argued at the appeal court was that the proscription order by the Federal High Court in 2017 was obtained through the ex parte application by the federal government instead of through a hearing on notice by a judge in chamber. He said that they also argued that the proscription proceedings offended the hallowed doctrine of fair hearing, provided in Nigerian constitution, given that IPOB was neither put on notice nor heard before the proscription order was granted. The special counsel further contended that the proscription directive issued to the Attorney General was signed by the then Chief of Staff, Abba Kyari, now late, and not the then President Buhari, in line with law. The Court of Appeal acknowledged these laxities, but it still went ahead to dismiss our appeal on the quaint premise that national security is an exception to the provisions of the Constitution. One then wonders when herein lies the national security risks posed by the IPOB in 2017 that warranted the flagrant breach of the Constitution, that in its intent and effects discriminatorily targeted the Igbo as a whole, he said. Mr. Ejimako stressed that the Constitution laid down the process to be strictly followed before any provision of the Constitution could be suspended for the sake of national security. But in this case, this process was not followed at all, he said. Aside from IPOB's proscription, Mr. Kanu is being prosecuted for alleged terrorism at the Federal High Court in Abuja. Mr. Ejimako argued in the statement that the appeal court's ruling will hardly have any prejudicial effect on Mr. Kanu's trial at the Federal High Court. Thus, this, he explained, was because the appeal court ruling was not final and the IPOB leader has resolved to challenge the judgment of the Supreme Court, which is the final arbiter. The Special Counsel threatened legal action against any person or entity who would take undue advantage of the IPO court ruling to cause legal injury on Mr. Kanu and Igbos. So for the time being, it is legally safer and wiser for all and sundry to resist the dangerous temptation of calling Mazi Nnamdi Kanu a terrorist until he is either convicted as one, which is a tall order, or until the Supreme Court finally decides it against him, which is highly unlikely. In plain terms, the jury is still out on the issue of whether the IPOB and Mazi Nnamdi Kanu are terrorists or not, he said. Thus, anybody or entity that seizes the adverse moment to parry the label that Mazi Nnamdi Kanu or IPOB is a terrorist will be countervailed by epic legal actions that will be prompt, muscular, and scorched earth. Simple and short. Nobody should actually try to say, open their mouth to say that yes, they affirm that IPOB or Mazi Nnamdi Kanu is actually a terrorist group or person. Because the Supreme Court has not finalized it yet. And you can't base your thoughts on assumptions or your words on assumptions and expect them not to carry legal actions against you. Because that will be tarnishing his image, and that's false claims. So yeah, he needs to be punished by law. But then the Court of Appeal is saying that IPOB is actually a terrorist group. Or in their words, they are prescribing that IPOB is a terrorist group. Everyone should focus their mind on the real terrorists, Boko Haram, herdsmen, and the rest of them. They should focus their attention and their mind on the real terrorists. These people are in the southeast. Southeast are not complaining. Focus your attention on the real terrorists that are labeled terrorists and get them. But no, you're causing more uproar in the southeastern zone with the fact that you're claiming IPOB is a terrorist group. Anyways, the Supreme Court has not yet finalized that claim, so we'll wait till then. We've come to the end of today's content. Do not forget to subscribe and stay tuned to our channel. Thank you.